To a lot of people listening who aren't familiar with how the federal government works, they might go, well, clearly there was a performance or a conduct issue. But in the federal government, in order to dismiss somebody, you really have to specify some kind of specific shortcoming that they had. And performance and or conduct does not cut it under the federal rules and regulations. That's a monument to bad grammar, because was it performance? Was it conduct? Was it both? And nothing was ever pointed out to us. I denied a continuance from someone who didn't provide any evidence, which is clearly required under the regulation that governs continuances. So I had a sum total in 2 years of 4 complaints filed against me, all of which were dismissed as baseless and frivolous. And this is pretty typical. Most of the judges that were dismissed either right before or along with me had the same sort of thing happen. Then, of course, after I was dismissed, there were a number of private bar attorneys who came out on Twitter and said that they were specifically engaged in a campaign to crowdsource complaints against constitutional conservative immigration judges.
Yeah, I saw some of these tweets from lawyers and groups like AILA who straight up basically admitted that their complaints were politically motivated. They had nothing to do with your performance. They were just mad that they weren't getting the rulings that they liked. And so they openly admitted, hey, we're going to just flood the process with complaints to get judges who are ruling in a consistent manner with the law removed from the bench. Why do groups like AILA have so much sway with this administration? And how is this tactic of flooding the process with complaints legal, or is it legal?